Citizens, I am Francis Derito KARURU. I am not a lawyer. I am a teacher by training and trade. But above all, I am a citizen of the Republic of Kenya. I want to start by apologizing because, for one, I do not have the facilities to record the kind of video that has the standards perhaps that we are used to. I don't have a studio. You might hear the sounds of children playing outside there. You might hear the hum of a fan. I don't have a lip or microphone, and plus many other problems. But like we say, in life, if you wait until it is perfect, you may never do anything. Now, citizens, I want to title this series of video presentations as the court of public opinion. We have the court of law, which are public institutions. Now, we respect those courts of law out of honor, because the people who serve there, they should be protected from external influence, fears, concerns, and so on. There could be a problem there, because when you overprotect a public servant, then our power goes to their heads. And in the process, the quality of service that we get is scaled down. Now, citizens, justice belongs to the public. It does not belong to the people who proclaim justice. It does not belong to politicians. It belongs to the public. It is proclaimed in the name of the public. Citizens, justice belongs to the public. Justice is proclaimed in the name of the public. The public must be allowed to discuss their justice, must be allowed to discuss the quality of the justice that they are getting. The public can only discuss that quality if the public is ready and willing to interrogate the justice that is proclaimed there. If, and I want to say this again, if we overprotect the people who serve in the judiciary, that is going to be interpreted as power to them, and it will go to their head, and they'll turn around and bite us. It is for that reason that I have decided to publish this series of videos as the court of public opinion, so that what happens in court can get into public circulation, not as live recording of the court proceedings, but as an extract from the documents of what happened or did not happen in court. Now, De Bono is a Spanish philosopher. He says that proof is lack of an alternative explanation. Proof is lack of an alternative explanation. So, in my presentations, where you find a decision has been made and there is no alternative explanation as to why the justice proclaimed was proclaimed like that, then we'll have been left to put a huge question mark on that decision and the judicial officer who made the decision. I'll straight away say that judicial officers, like other public servants and everybody else, they must be ready to stand by their hard work. Let me repeat that. Judicial officers must be ready to stand by their hard work. It is the work they do. It is what they are paid for. If they feel they cannot not stand by their hard work, then they must stand aside and look for something else to do, such as roasting maize by the roadside, for example. Now, in this series of video presentations, the first of those presentations that I am going to present is on the decision of the Honorable Justice James Wakiaga when he was stationed in the Nyeri Law Courts. In those law courts, he made a decision in the High Court Miscellaneous Application number 57 of 2013. I call that a decision. You can think of it as a judgment, as a ruling, but I prefer to call it as a decision, something that is personal, something that bears his brand. Now, I call it a decision, but really it is an undecision. Now, citizens, I prefer to call Justice Wakiaga's decision an undecision. Now, that is in the line of George Orwell's novel called 1984. Many of us know George Orwell through his book Animal Farm. He has written many other books like Burmese Days and so on. It is in 1984 that George Orwell talks of somebody being unpretty, for example, instead of saying not pretty or ugly. So I prefer to call some of the decisions made in our courts as undecisions. They are undecisions because they do not conform to the law. And if a decision made in law does not conform with the law, then it is undecision. It's open for appeal, for example. But when one party chooses not to appeal to the extent that the dates for appeal expire, then it stays as an undecision, and you are free to highlight why it is an undecision. Now, the second series, under the Court of Public Opinion, is going to be on one person. Now, this person is called David Bura Kenyajui. Now, David Bura Kenyajui is a trained lawyer. Now, what makes David Bura Kinyajui worth discussing under the court of public opinion? Because David Bura Kinyajui brings out the worst about our judiciary. Those of us who remember, once upon a time, there was an accident on Thika Road. This accident involved a lorry owned by the prisons department of the Kenya Police. Quite a number of prison wardens died in that accident. Now, the accident and the death were the subject of a court case. In this court case, there were two Kinyajuis. One Kinyajui was the lawyer who filed the case to claim the insurance money or compensation for the families who lost their loved ones. The second Kinyajui is the David Bura Kinyajui. David Bura Kinyajui was a state council those days. Now, state councils are lawyers who are in a department, or used to be in a department, in the Attorney General's office. In a nutshell, David Bura Kinyajui is recorded in court as having entered into an agreement on behalf of the Attorney General for a settlement of the claim. At the end of the day, 52 million Kenya shillings was paid to David. 52 million Kenya shillings was paid to Kinyajui, the advocate for the victims. Now, the courts, the judges who have handled this case and the appeals, they have recorded there that David Bura Kinyajui had not been authorized to enter a settlement. His recording of a settlement was a private setup, a kapari. And as a matter of fact, one judge hopes that David Bura Kinyajui does not practice law anywhere in Kenya. But you'll be shocked. David Bura Kinyajui does practice law in Kenya. However, he is recorded in the Law Society of Kenya website as not having paid the statutory fees to the Law Society of Kenya since before 2011. To date, he has not paid up the statutory fees to allow him to practice law in Kenya and to allow him to represent clients in Kenya. So really, David Bura Kinyajui is not qualified to represent parties in court for the simple reason that he is not licensed to represent clients in court. But what has been the reality? I have personally presented a printout of David Bura Kinyajui's unconformity with the law to a person serving as a judge today, and the judge declined to receive that printout. I have filed written submissions which included a printout from the website of the Law Society of Kenya, which indicated that Mr. Kinyajui did not conform with the law to the extent that he had not paid up the statutory fees and was therefore not licensed. But each time, David Bura Kinyajuи would continue to represent clients in court. Now, this has happened as late as 2019. Judges do not want to accept that Mr. David Bura Kinyajui is technically not an advocate and should not be representing clients in court. And we ask ourselves why. And I want to fall back on the bonus statement that proof is lack of an alternative explanation. Other lawyers need to subscribe to get their licenses to practice law. If you don't have a practicing license, you are not an advocate. You might have learned as a lawyer in college, maybe even have a PhD. But if you don't have the license, then you are not an advocate who can represent clients in court. It's as simple as that. Now, it happens that for all the time that I have known David Bura Kinyajui, he has always served in the law firm of Madzayo, Mrima, and Jadi. This law firm has changed names for some time. Its current name, Madzayo, Mrima, and Jadi, tells you and me that this law firm is owned by one serving judge. One serving judge. One serving judge has been sending an unqualified lawyer all over Kenya to represent clients. Justice cannot be proclaimed by a crook, by a criminal, by somebody who does not conform with the law. So here is a judge whose side hustle is a law firm in which a gangster earns money for him. I want to repeat that. A serving judge is sending a gangster to go work for him. And he works for him. And he earns money for him. Am I not choosing the wrong word in describing Mr. David Bura Kinyajui as a gangster? My understanding of gangsterism is a situation in which we abandon the path of the written law. I want to repeat that. Gangsterism is where we abandon the path of the written law. And we established a parallel authority. And that is what has happened in court. That Justice Anthony Murima has sent Mr. Kenyajui, a person who is not qualified to represent clients. And Mr. Kenyajui has come to court and outside the law has represented clients, has guided judges, has taken over courts. Now that is gangsterism, because there must be an authority somewhere that allows Mr. Kenyajui to capture a corner of the public court and earn money for himself and for his master, Justice Anthony Murima. Now the law firm of Madzayo, Murima and Jadi, also has a former judge. The former judge is Justice Madzayo. People know him as Justice Stewart Madzayo. Justice Stewart Madzayo has since joined politics and is currently a senator. Now that is a lot of power. It's a lot of power. It is similar to my producing a gun from somewhere and going to a school and taking up the school. I have power, but I'm a gangster. So that is going to be my second series of videos. Now, my third series of videos is going to be on the office of the Director of Public Prosecutions. Now, in that presentation, I'll highlight the office of the Director of Public Prosecutions as the weakest link in the justice chain. The weakest link. See you then.